thank you to our dignitaries for launching the magazine and the book. I hope it serves as an insightful experience to all its readers. We are honored to have with us, among us today, Honorable Dr. Justice D.Y. Chandrachud, former Chief Justice of India. Dr. Chandrachud has an illustrious legal career marked by exemplary service and academic excellence. Justice Chandrachud, who served as the 50th Chief Justice of India, has authored more than 590 judgments during his tenure as judge, including over 30 Constitution Bench judgments. He has delivered transformative judgments on a broad array of issues, including privacy rights, rights of the LGBTQ community, women in armed forces, marital rights, environmental issues, and other socio-political matters. During his tenure, he has brought transformative changes to the functioning of the Supreme Court and the Indian judiciary, combining a commitment to constitutional values with a forward-looking vision. His leadership witnessed the Supreme Court's disposal of 1,000 bail matters, economic offence cases, and constitutional disputes, reinforcing faith in timely justice delivery. His tenure is widely regarded as one of the most progressive and reform-oriented in recent times, leaving behind a legacy of a more accessible, inclusive, and citizen-centric judiciary. He is currently a distinguished professor at National Law University, Delhi, and has been nominated as an arbitrator in international arbitrations by the International Chamber of Commerce, by the Singapore International Arbitration Centre, and the London Court of International Arbitration. Sir's contribution to the legal fraternity is innumerable, and we are all in awe of his commitment to work and legal scholarship. Sir, we are honored by your presence today. We invite you to please deliver today's keynote address, which we all have been waiting to listen to eagerly.
Shri Sunil Bartwal, the Commerce Secretary to the Government of India, Professor James Nedumbara, Professor and Head of Department of the Center for Trade and Investment Law, Professor Rakesh Mohan Joshi, Vice Chancellor of the Indian Institute of Foreign Trade, distinguished members of the faculty, young lawyers, resource persons, and guests. I must tell you that at a very interesting breakfast at the St. James's Court Hotel in London about 3 years ago, when the negotiations for the UK-India FTA were going on, I was sitting by myself in the breakfast room. I had my fan moments over the time that I stayed at the St. James's, because it appeared that all of Delhi had descended in the Taj property. So I would chance upon entertainers, writers, intellectuals, sports persons, and walk up to them and exchange a moment or two. And when I was having breakfast one morning, a very senior member of the legal profession who was accompanying the team, he said that he is doing it only for 1 rupee of consideration, because the profession had given him much more than he could expect. Said that, well, a very young team from the Ministry of Commerce, which is here for the negotiations, would like to come and meet you. So I said, with great pleasure. And over the next 20 minutes or a half an hour that our conversation lasted, I was fascinated with the range and diversity of the knowledge, the insight and the vision of these young people from the ministry who are leading our negotiations. In fact, years ago, when I was the Additional Solicitor General of India, there was a challenge to India's commitments to the WTO, which I had to defend as law officer for the government in the Bombay High Court. And there again, on a Saturday morning, a very young officer came to me from Delhi, and I just sat back at 9 o'clock with the person who was deputed to brief me until it was time at 6 o'clock in the evening on a trot without a break. And he said, I think I have to leave for the airport, otherwise I will never reach home on time. So in that sense, it's a matter of joy to be here at the house of experts on the foundation day of the Center for Trade and Investment Law, as we mark the book launch of a timely publication titled The Bespoke Treaties or Standard Models. The book is an outstanding example of the pioneering scholarship that CTIL has been consistently producing. I thank James Nedumburgh for extending this invitation to me on behalf of the Indian Institute of Foreign Trade and CTIL. In preparing for this address, I must confess that I have learnt more than I can share with you over the next few minutes. But I was really touched by his own reference to his spouse who's traveled all the way from Trivandrum to be here this evening. And I must tell her that that's exactly what he was so proudly discussing with me and sharing with me when he came home at our previous residence. He's deeply, deeply proud of the wonderful work which his spouse is doing as a member of the civil service. CTIL, established in 2016 by the Government of India, represents a cutting-edge effort to promote and facilitate research in and the development of international trade law frameworks. Over the years, CTIL's work has comprised foundational research on WTO law, investment treaties, digital trade governance, informing India's approach and position in international trade forums. CTIL has undertaken several noteworthy policy and capacity building initiatives. Therefore, I congratulate the authors James Nedumburgh, Sunanda Tiwari, and Pushkar Reddy, and all others at CTIL who are involved in this book. I'm not sure whether Pushkar is reaching out to this event online because he's at Harvard, where one of my former law clerks, Nivedita, is also participating in what I believe the first 2 weeks of the orientation program. In an era of profound global economic shifts, the book holds great value and provides an essential compass in navigating international investment agreements executed between India and her trading partners. As we have witnessed in recent days, fiscal impositions, including tariffs, have become a significant source of challenge to our own sovereignty. India's emerging status as a responsible nation on the global stage has to be supported by robust domestic institutions which promote capacity building. The nation needs a high level of research-based analysis to navigate the interface between geopolitics and a changing global economic order. While it is true that there has to be a greater interface between government and the private sector, and I accept that perspective as well, having spent 25 years of my life in a state institution, the Indian judiciary, I'm still deeply impressed with the quality of the talent which we have, our own homegrown talent. So while we welcome this continual exchange between and within and outside government, it's equally true that there are matters in which we have to have our own teams. And when I was in the judiciary, that was reflected best in our technology mission. We didn't go to the proprietary multinational giants for bringing about a transformative change in the Indian judiciary. It was our own people, trained and aware of Indian conditions, who brought about so many of the transformative changes that we have been able to put together, whether it was in terms of live streaming, whether it is in terms of digitizing court cases, transcription of arguments, translation of Indian judgments from English into every language recognized by the 8th schedule, the 22 languages, and what have you not. International investment agreements, which are known by their popular acronym BITS when spoken of in a bilateral context, serve to facilitate greater investment flows between two signatory countries. These treaties, structured around a set of principle-based obligations, provide a protective umbrella in terms of the standards set for protecting investments, as well as the rights of those investing. The bilateral investment treaties and IIAs are not governed by a centralized framework. In that sense, they are reflective of the fragmented character of international trade that permeates international trade law itself. This means that there is a constant tug of war between the key players in the process. On the one hand, investors invest capital with the expectation of earning sustained profits, dividends, capital appreciation, and financial growth. They bank on fundamental principles of the rule of law, grounded in the certain, transparent, and objective application of treaty standards and a legal regime which respects them. In that sense, building up capacity within our own legal framework is crucial because it's in the robust application of domestic institutions which interpret laws and apply laws to factual contexts that the confidence of the investing community, domestically and overseas, depends. On the other hand, we have host states which have significant public policy concerns which are grounded beyond a purely contractual relationship. These considerations may be based on fiscal policy, public health, environmental governance, consumer rights, labor welfare, or sectoral protections, including agriculture. These may be pictured as vessels, the host states may be pictured as vessels, absorbing foreign finance to fuel economic growth, generate employment, improve infrastructure, and seek intangible assets like intellectual property. Their expectations are synergetic in nature. There are greater and far-reaching risks and rewards at issue for these states beyond immediate investment. It also remains a field marked by power imbalances. In such a backdrop, the adoption of an interest-based approach to treaty negotiation and formulation attains importance. The book which we have just launched presents a comprehensive analysis of the depth and character of the IIAs of India's major trading partners. It commences with a panoramic view of the architecture of investment agreements and their key requirements. Then Chapter 2 provides an interesting analysis of what the investor-state dispute settlement or the ISDS mechanism will look like in the coming decades. The book also undertakes a scrutiny of investment treaty provisions across continents. The methodology of comparative policy adopted by the authors is, to my mind, commendable. Lawyers and judges are trained to first understand the provisions of a statutory instrument as it stands. Read the statute, as Justice Frankfurter said, before undertaking an examination of the context in which it was birthed and analyzing plausible interpretations grounded in the principles of statutory interpretations. The authors have adopted a somewhat similar approach in a text which makes for an engaging read. The authors have set out the policy backdrop to these treaty instruments before assessing their key provisions in the context of international obligations, bringing together an ecumenical assortment of ideas and insights from around the world. Chapter 12 will be of great interest to those seeking to understand the present-day position that India occupies in the scheme of global trade patterns. They have presented a nuanced assessment of the trends that have marked India's journey into the 21st century. The importance of research-backed analysis and public opinion in fortifying trade policy has been captured by an economist, Anne Kruger, in a book titled International Trade, What Everyone Needs to Know. She writes, and I quote, "A country's trade policies are the outcome of the political process. The political process, in turn, depends on the interaction of key players. Those key players are special interests of various groups, often pressuring and lobbying in their narrow self-interest for protection and the general public. When politicians yield to special interests, consumers and the public interest for the whole are harmed. The only real bulwark against these pressures is public opinion and economists' arguments buttressed by research analyzing experience with trade policies. Public understanding of the effects of trade policy is therefore crucially important as a bulwark against the pressures of special interests." The modern global system of economic regulation rests upon multilateral systems established by the Bretton Woods Conference in 1944. India was a founding contracting party to GATT as well as a founding member of the WTO. Domestically, however, India continued to toe the line of import substitution until the advent of the economic reforms which took place on and after 1991. Members of the audience who are my age or older will recall that imported goods were a scarce commodity. India began exploring free trade agreements after 1991. These reforms promised a sui generis approach to cross-border trade, a flexible exchange rate regime, and foreign direct investment. But above all, our constitution, adopted in 1950, established a framework for social welfare through the directive principles of state policy, emphasizing economic justice and distributive equity alongside fundamental rights, protecting trade and commerce. India's founding document established a federal division of trade governance authority between the central and state governments. The union government received exclusive jurisdiction over foreign trade, interstate commerce, and major taxation sources, while the states retained authority over intrastate trade, agriculture, and local industries. This distribution created a complex regulatory landscape that would later complicate India's implementation of international trade agreements. The Supreme Court emerged as the ultimate arbiter of constitutional disputes involving trade and commerce, developing an extensive jurisprudence balancing economic freedoms with state regulatory authority. This period witnessed the development of architecture premised on what Professor Jagdish Bhagwati termed the inward-looking strategy, with statutes like the Industries Development and Regulation Act 1951, the Foreign Exchange Regulation Act of 1973, and the Monopolies and Restricted Trade Practices Act of 1969, so much of which was bread and butter for us as young lawyers. But how times have changed, with cooperative federalism now assuming the center stage of domestic economic policy in terms of the GST. The balance of payments crisis in 1991 triggered a fundamental reorientation of India's economic policies and engagements with the global trading system. Our reforms dismantled the license permit Raj, reduced tariff barriers, liberalized FDI, and initiated India's integration into the global economy. This paradigm shift coincided with the Uruguay round of negotiations establishing the WTO, providing India with an opportunity to strategically engage with multilateral trading frameworks while protecting its developmental interests. India signed its first investment treaty with the UK in 1994. Since then, as the book tells us, until 2015, it had signed BITs with 83 countries, of which 10 did not enter into force. These BITs were largely based on India's model BIT at the relevant time. The post-liberalization period transformed India's economic trajectory and global trade positioning. India's merchandise exports grew from 18 billion in 1990 to over 300 billion US dollars by 2020 and 374.1 billion US dollars in 2024-25, while service exports expanded from $5 billion to nearly $387.5 billion during the same period. Foreign direct investment increased from negligible amounts in 1990 to annual inflows exceeding $81.4 billion by 2024-25. India's economic composition shifted from primarily agricultural to services-led growth with software, business process outsourcing, and professional services becoming major export sectors. In December 2015, the government approved a revised text of the Model BIT. The Model BIT was intended to be used for the renegotiation of existing BITs and negotiation of future BITs and investment chapters in regional agreements. Following the approval of the Model BIT, India issued notices for unilateral termination of the earlier agreements, except with Bangladesh. But there has been a recalibration, as we will shortly see, of the investor-state relationship over time. India's BITs have featured broad protections for investors, including fair and equitable treatment, national treatment, the MFN provisions, and investor-state dispute settlement mechanisms. These treaties would later become a source of significant liability as foreign investors challenged regulatory measures through international arbitrations. Several scholars across the globe have advocated that countries would benefit greatly from tailoring treaties in line with their domestic requirements and motivations. These countries include Indonesia, South Africa, the Czech Republic, Peru, Bolivia, Ecuador, and Venezuela. India has not been alone, therefore, in rethinking the benefits of its international investment agreements. This development has, in a sense, been perhaps succinctly described as a backlash against investment treaties, or at the very least, an attempt to recalibrate the relationship between foreign investors and host states. This has also been at the center of the work under the UNCITRAL's working group on ISDS reforms. In India, having faced at least half a century of notices and claims with a cumulative value in excess of 100 billion US dollars, investment treaty arbitration is no longer an esoteric subject that can be ignored by the legal community, not least by policymakers who are part of treaty negotiations and those who handle the disputes. The outcome of disputes arising from investment treaties and FTAs has real consequences for the state as well as the public exchequer. So what are the lessons which we gain from the Indian jurisprudence and experience? The 2007 Vodafone-Hutchison transaction triggered a transformative conflict that would expose tensions between India's regulatory sovereignty and international investment obligations. I must, at the outset, enter a disclosure because it was my decision at the Bombay High Court, which was reversed by the Supreme Court, which began the tryst in Vodafone. Vodafone's acquisition of Hutchison's Indian telecommunications assets through a Cayman Islands transaction raised questions about the application of India's capital gains tax to indirect transfers of Indian assets. The Indian Supreme Court's 2012 decision in Vodafone International Holdings BV versus Union of India upheld the validity of the transaction, ruling that the Income Tax Act could not be extended extraterritorially to cover transfers between foreign entities of shares in foreign companies holding Indian assets. The Finance Act of 2012 retrospectively amended the Income Tax Act to override the Supreme Court's decision, asserting India's right to tax transactions involving indirect transfers of Indian assets. This amendment applied not only prospectively, but also retrospectively from 1962, creating liability for Vodafone and other companies that had engaged in similar transactions. The retrospective amendment would eventually lead to multiple investment treaty arbitrations against India. Cairn Energy challenged similar tax demands under the India-UK BIT. Both tribunals ruled that the retrospective taxation violated India's obligation to provide fair and equitable treatment to investors. The Cairn Tribunal particularly emphasized that India's actions breached the legitimate expectations of investors who had structured transactions based on prevailing legal interpretation. The tribunal awarded Cairn Energy 1.2 billion US dollars in compensation plus interest, one of the largest awards ever issued against India in international investment arbitration. President Pranab Mukherjee had developed a very interesting practice of inviting individual judges and their spouses to Rashtrapati Bhavan as a part of knowing the judges, particularly in the Supreme Court. He would do his homework up to date on every aspect of your performance right since the inception. And then he would ask me any question about my role in public life. So he bent over me when we were having a cup of coffee at Rashtrapati Bhavan and said, you know, whatever the international community says, I believe that the Bombay High Court judgment authored by you was absolutely correct. So I said to him, Rashtrapati ji, there could be no better compliment than this little word of appreciation from the head of the nation. At the same time, we have to be cognizant of the fact that out of the half a century of notices, some disputes have been settled. And in those where we have had an arbitral award, 5 have gone against India: White Industries, Devas, Deutsche Telekom, Vodafone, and Cairn Energy, while 6 awards have been in favor of India: Bicel, Astro, SAEHL, Louis Dreyfus Armatures, GPIX, and Rakia until date. As I see, the reason why awards now have bucked the trend and are really going in favor of India is because of the enormous capacity building effort which has gone into the process. I think our ministries and the government of India, including the Ministry of External Affairs, have realized in a very robust way that if you invest in qualified professionals to lead the charge, either of India's defense or attack, as the case may be, the results will show. The Vodafone and Ken cases were settled after the awards were rendered by amending the legislation and didn't go through the entirety of the enforcement proceedings. It is here that I'd like to share from my own experience. In deciding or laying down the law in significant arbitration or commercial matters, it is important to study the practice in other jurisdictions. India cannot afford to remain isolated. For example, while deciding cases like arbitrators' fees in ONGC versus AFCONs, in deciding the application of the group of companies doctrine in Cox and Kings, arbitrator bias in the case of Core, and the ambit of the referral court in entering upon stamping of arbitration agreements, our court studied the global jurisprudence in these areas through cases from foreign jurisdictions, international journals, and ancestral case digests. George Pothan and the PCA in particular, Manisha Singh is here, they had given us a beautiful compilation of material which was so helpful for us in navigating what the international community thinks about in terms of these issues. And looking at these issues in a comparative law context has sent a message across the globalized world that India in that sense is integrated into the broader international community. They have helped us in furthering the international rule of law, imbibing the best practices from across the globe, and furthering the harmonization of law, all within the legislative framework, keeping in view our international obligations and the intent of legislation. So in that sense, there is no dichotomy between international trade law and domestic legal and constitutional frameworks. As you see across in the last 10 years, there has been a growing internationalization of our domestic law and our constitutional law, and an increasing constitutionalization of international law. So there is much that both spheres across the world have learned from each other. Beyond drawing from global jurisprudence, India has also meaningfully contributed to it. A notable example is the Supreme Court's 2016 decision in Cento Trade Minerals versus Hindustan Copper, which upheld the validity of a two-tier arbitration mechanism, namely one arbitration followed by a more or less appellate remedy. This landmark ruling, now under consideration by Ancestral Working Group 3 as a potential model for ISDS reform, illustrates how Indian jurisprudence can inform international dispute settlement design. It is therefore that the books released today and the initiatives of CTIL are crucial for the legal community, policymakers, and academics. I say the last part with a sense of responsibility, having participated in all the capacity building exercises hosted by PCA and Ancestral over the last decade, noticing the importance of how judicial decisions or non-decisions can also lead to an investment treaty claim. For those wondering how actions of state courts can form the basis for investment treaty claims, don't look further than the watershed moment in India's investment treaty journey, the White Industries case. The correctness of the award or outcome is a debate for another day, and one should read the legendary Fali Nariman's Herbert Smith Freehills Singapore Management University Asian Arbitration Lecture of 2014. Under international law, a state includes the executive, the legislature, and the judiciary. As judges, we were always fond of saying that we are not part of government. We are part of the nation state. But looked at from the perspective of an investor, the state does include all the three arms, and therefore the need today to upgrade the infrastructure and the institutional competence of our courts if we have to truly become a community in the international world. In today's world, along with international courts, arbitral tribunals perform a crucial role in the enforcement of the rule of law within the community of nations. In a world infinitely more complex than the one at the beginning of the 20th century, business and human rights violations, environment and climate change issues are often inextricably intertwined with economic affairs and such issues sometimes lead to investment disputes. The outcome of these disputes impacts the global economic order and the sovereign concerns of states which are hosting the investment. In such a complex world order interlinked by trade and technology, we cannot remain an isolated post. Doing so requires us to be cognizant of what is happening around us and modulate ourselves to be in sync with an ever-changing world. Therefore, this book is an essential guide for anyone invested in India's future, offering deep insights into complex world of international investment law. Beyond theory, the book grapples with real challenges and opportunities in investment treaties, serving both as a reference and a spark for better decision-making and strategic foresight. Understanding the complexities of FTAs and investment treaties is no longer optional, but imperative. To our policymakers engaged in treaty negotiations, the model BIT is only a starting line. India is no longer just a capital importer. It is also a global investor. Outbound investment by Indian firms increased from $24.8 billion to $41.6 billion, a growth of 67.7% in sectors as diverse as IT and IT services, energy, automotive industry, pharmaceuticals, and hospitality. We must clearly define our priorities and goals, balancing the protection of corporate interests with sovereign rights. Investment treaties are not shields for the state, but instruments of mutual assurance, calibrated to balance expectations and authority. Our decision, therefore, not to terminate the BIT with Bangladesh reflects this approach, given India's greater investment in Bangladesh than vice versa. This outcome underscores the importance of informed decision makers. Through capacity building efforts, the MEA has made progress, engaging experts, establishing arbitration cells, and working closely with international bodies. Now, 8 years into its infancy, CTIL continues to lead in research and dialogue, significantly enhancing India's ability to craft informed, resilient investment strategies. Such an independent think tank should aspire to be the repository of India's investment treaty framework, FTAs, and related dispute knowledge. Investment treaty arbitration jurisprudence in India is still developing, as the country has yet to host an India-seated investment treaty arbitration or enforce such awards domestically. Key judgments in the Vodafone and Khaitan cases have highlighted challenges arising from India's commercial reservation and the Arbitration Act's traditional limitation to commercial disputes, excluding investment treaty disputes. But the 2015 model BIT clarifies that awards under investment treaties should be treated as commercial awards for enforcement under the New York Convention, aligning with similar provisions in earlier treaties with Austria, Sweden, and Kuwait. This reflects the government's intent to harmonize India's arbitration regime with international standards, underscoring the need to interpret the term commercial disputes as contained in our arbitration framework broadly as suggested in the UNCITRAL model law to foster effective recognition and enforcement of investment treaty arbitration awards in India. During the last budget speech, the Honorable Finance Minister stated that the 2015 model BIT is due for a revamp, taking into account the number of treaties signed since 2015 and also projecting India as an investment destination. I take the liberty to suggest that CTIL can perhaps do an authentic research and database study and submit a report which could assist the government. Let me then conclude. In a collection which has been titled Emerging Powers and the World Trading Systems, the Past, the Present, and the Future of International Economic Law, the noted trade lawyer Gregory Schaefer has put forth a set of perspectives that countries can consider to foster trade law capacity. Trade law capacity is inextricably linked with broader trade policy-making capacity. Further, it rests on the ability of countries to implement and monitor the implementation of trade agreements. The inability to participate in global trade markets can adversely affect a country's social welfare. For instance, One of the remarkable outcomes of our economic reforms is in securing international contracts. We have become a country that grows not only our own food grain, but also our own technological capabilities and the human capital required to service these capabilities. 208 years later, Ricardo's theory of comparative advantage may explain why India could thrive in software services, exporting what it did best, driven by a middle class which places faith in a robust education for her daughters and sons. International legal capacity building is also important to defend market access rights and investor comfort. The book describes this as bargaining in the shadow of law, by which countries can negotiate favorable settlements. Such capacity also goes a long way in obviating capture by protectionist sectors within the nation. Such capacity can also translate into a greater role for the country's lawyers in international private settings, such as negotiating cross-border contracts. Decision makers in the government can seek to leverage their experience to modify constraints and engage with the flexibilities of legal frameworks to ensure sector-specific growth. I therefore leave you with just 9 bullet points and I'll be done. First, there is no real conflict or dichotomy between international trade law and domestic legal and constitutional frameworks. Second, much of today's economic order was devised in the context of a world which was marked by power imbalances, perhaps a bipolar world. But the bipolar world gave way to a multipolar world, and now even multilateralism faces an existential threat. Third, there are innovations which all of us need to develop upon. Just one of them, the India-UK CTIL has a provision for open hearings for dispute settlement mechanisms. Fourth, we need the new kind of lawyer who can navigate data protection issues, climate change litigation, and the digital-first regulatory framework. CTIL must be complemented for its experiential learning program through TradeLab clinics in international economic law. I think we need to take this further by permeating almost all the national law schools in the country with this trained body of experts that CTIL can contribute to generating a new breed of lawyers, some of whom will, of course, join government, but the others will spread their wings across the world. Fifth, traditional models on international dispute resolution, which developed in a global order marked by power imbalance, gave way to a bipolar world, and which has now given way to a multipolar order, which warrants a fundamental rethinking of dispute resolution. Sixth, India must move from a one-size-fits-all approach in model BITs to bespoke treaties which account for our strategic interest. Seventh, India must invest in legal infrastructure, which constitutes the virtual semiconductors for our economic trajectory. Eighth, the India-EFTA TEPA combines investment promotion, job creation, and FDI. The India-Brazil CFI combines investor obligations and replaces ISDS with an ombudsman and a joint committee. Perhaps we have to go beyond traditional modes of thinking into new and innovative forms of dispute resolution. And ninth, which is not the least, that India has a real voice at the table in the global south with its own resilient institutions. Finally, in this context, the work of CTIL and the scholarship showcased today in the book are invaluable. They sharpen India's understanding of complex investment treaties and trade frameworks, arm our policymakers and legal professionals with critical insights, and ultimately underpin a future-ready India that confidently asserts its place in the evolving international economic order. I congratulate James and the other authors and urge audiences here and beyond to give the book a read. Despite the varying nature of their functions, challenges, and opportunities, academics, policymakers, decision makers within the government, judges, lawyers, Essentially, anyone struggling to seek a vectored solution to strengthening Indian trade frameworks will find in the book more than a kernel of truth and a large serving of history, contemporary knowledge, and the skill sets necessary to navigate the complex field of international trade law. Thank you very much for inviting me.